Can a crime victim press charges? Actually, no. Can a crime victim drop charges? Again, the answer is no. But those are phrases we use a lot. So I thought I'd just talk generally about sort of, the criminal procedure. This has been inspired by a story about a footballer, but it's of general applicability. Okay, so let's just start with the basics. One thing that you've got to remember about a criminal trial is the victim is just a witness. They're not a party to the trial. It's the Crown against whoever the defendant is. Now, obviously, we are trying to get a sort of more victim-focused sort of approach to the criminal justice system. But the current problems, and certainly the historical problems, were all based on that fact. That the purpose of the criminal justice system isn't to sort of right wrongs for individuals. It's to, maintain the peace and security and stability of the realm. And that's why the Crown feels able to get involved. I mean, it used to be that, it was all left to your own devices, sort of back in the old days, in the Danelaw, for instance. You'd pay the Wehrgeld if somebody assaulted you or murdered one of your family. Then you had all your options of blood feuds, but you could basically say, just pay a certain amount of money. And sometimes if there was a dispute, there would be a jury. Although Norse juries, because Viking's just a job description, it was actually 12 people who sort of knew everything. The idea with juries then was, well, actually, the best 12 people to judge are people who actually know all the parties. We know Olaf likes to kick off when he's had a few, horns of mead, and therefore we're more inclined to believe that it actually was self-defense or something like that. So that's how the procedure started. And then over time, it was basically, okay, here's the deal. To stop all this, private blood feuds and everything, the state will take over prosecuting crimes. And in return for that, we promise that, there will be some element of justice. People will be punished and all that sort of thing. That's sort of where we are. But what does that mean in practice? Well, first of all, some terminology. I use the word victim. We tend to use either victim or complainant, depending on what's in dispute. If there's no dispute a crime has taken place, it's just who committed the crime, then we will say victim. If, however, it's still a dispute as to whether a crime even took place, then they're the complainant. So say, for instance, I'm up for assault for hitting somebody, and my defence is I wasn't there, I've got an alibi. So they'd be referred to as the victim, because I'm not disputing that somebody assaulted them, I'm just saying it's not me. But say, for instance, it was like, well, yes, I hit him, but it was self-defence. Then they're the complainant, because we haven't even established there's a crime yet. That is actually what is at issue. That's the basics, but I'll keep using victim. So what happens? Somebody basically reports an offence to the relevant authorities, usually the police, and they investigate. If they think there are sufficient grounds for charging somebody, they will do so, possibly after referring with the CPS. I mean, the CPS now are getting more involved at an earlier stage in proceedings, especially very serious crimes. They will start advising, even at the investigation stage and say, look, this is the evidence you need to be considering. Because in the old days, the police prosecuted things themselves. It wasn't until sort of 1984 that we got the CPS. I mean, technically speaking, prior to then, all prosecutions were private prosecutions, and it was the police officers who brought them. You used to get that actually out in some places out in the sticks in the magistrates' court. You'd get the police officers prosecuting the traffic court list. I've actually had that. I thought it'd been abolished, but I turned up at some court in the middle of nowhere. Although I do remember there was a river with an art gallery, sort of sculpture park on an island. So if anyone can remember where that is. And literally we just sat there drinking tea around this table with the clerks. I'm going to drop some biscuits. Well, this very nice sort of police superintendent went, right, your guy's up for a bit of speeding. It's like very surreal. But yeah, now the CPS they make the ultimate decision to prosecute, and the test they apply is two-part test. Is there a realistic prospect of conviction, and is it in the public interest to prosecute? So they will look at what's the strength of the evidence on each charge, and they'll decide the appropriate charges. But they also consider okay, even if we can prove all this, is it worthwhile actually prosecuting? Say for instance it's a relatively minor offence and it's a young offender or a vulnerable offender or something like that, they might say, well, there are other ways of disposing of this. But let's say it's a serious crime. That goes ahead, and they take a statement from the complainant stroke victim. And that effectively is, everything's been initiated by the victim. But of course, not all crimes are initiated like that. I mean, the classic example is murder. By definition, it's not the murderer who, initiates things. It's somebody else on their behalf. Interesting fact, in 60% of murders, it's the murderer who calls the police. That's why it's got such a high clear-up rate. So, that goes ahead. And at this stage, you might have a very cooperating witness. Yeah, I want this. Oh, yeah, I definitely want him prosecuted or her prosecuted. So that's what press charges means. It means, effectively, you have made a complaint to the police and it's been proceeded with. What if the CPS say, actually, no, we're not going to go ahead with this? Can the victim do anything about that? Theoretically, yes. Because the CPS is a public body, it's subject to review, judicial review. So you can bring a claim, but you have to show that the CPS acted irrationally. That their decision was so wrong that no reasonable person could have made it. It's not just enough that, well, actually, somebody else might have come to a different conclusion. It's a very high sort of bar, judicial review of a CPS decision not to prosecute. I mean, don't get me wrong, there have been successful challenges. So, it can be worth doing, but judicial review is very, very expensive. So not a lot of people take that route. What if the CPS sort of said, well, actually, we're not doing it. What, could you do anything yourself? Well, for a lot of offences, you can just bring a private prosecution. You can say, well, if the CPS aren't going to handle this, I'm going to bring it myself. There are some offences that can only be brought with the consent of the Director of Public Prosecutions. But for most offences, you can just what we call lay an information at the magistrate's court. It's a very simple procedure. And the legal advisors will have the forms and take you through it if you ask them. So you lay an information. Now, somebody could come along and apply to strike out at an early stage. They could say, well, look, there's no prima facie case, or this is an abuse of process. They could challenge that, and they would no doubt say the CPS didn't proceed against me. But that's not definitive. The courts have actually said the mere fact the CPS don't want to pursue something, it's irrelevant. We'll just look at it afresh and go, well, is there a case to answer here? So that's one way you can do it. And the thing with private prosecutions is they're quite a useful tool. I also advise this to people who are having problems with harassment, because as well as being a civil matter, it's also a crime. And if the police won't handle it, do it yourself. Because what's the advantage? Well, it's the cost thing. In civil proceedings, loser pays winner's costs. In criminal proceedings, if you bring a private prosecution and you're successful, you can claim your costs off the defendant. If, however, the defendant's acquitted, they can only get their costs back from central funds, and actually at a very reduced rate, just at standard legal aid rates. If you can get into the Crown Court, you can sometimes even recover your costs as a prosecutor from, even if it's an unsuccessful prosecution, from the state yourself. If they say this was, in the public interest to bring this, you actually, they pay you for it. So that's something to remember. And like I say, there have been successful private prosecutions of cases where the CPS said no. One thing is, though, the DPP can take over any private prosecution and either continue it themselves or discontinue it. So that's one way they can stop it. But again, that decision is reviewable. But let's say you sort of, you're going on and somebody changes their mind. It's like, I mean, this happens a lot in DV. And this is, a major problem because, people get lent on. People, especially in a domestic situation, it's like, well, if my partner is prosecuted and goes to prison, what happens to me? What happens to the kids? What about the finances? Or just generally, come on, kiss and make up or whatever. So let's say somebody discontinues. And this used to be a really routine thing, this. I mean, when you had DV cases and you were setting the direction, sometimes the judges would say, 28 days for the withdrawal statement, because it was such a common thing. But yes, somebody will say, I no longer wish to go ahead with this. And two things can happen. If they say, actually, I made it all up, then obviously that presents a problem for the CPS, because it's like, well, we can't proceed on this, because, the defence will just point to that. And even if they say, oh, well, she's been nobbled or he's been nobbled or whatever, but that causes problems. It exposes the person to, perjury, pervert the course of justice. Usually it's, I no longer wish to go ahead with this. So what happens? I wish to drop the charges. Well, again, it's not up to that person because they're just a witness. So, what are the options? Well, they used to just, witness summons people. Um, but part of the problem with that is, again, the argument was, well, it'll stop people leaning on people to withdraw because it's like, well, it's not up to me. There's no point telling me to withdraw because I'm not allowed to. But then you had that bizarre situation where, alleged victims of crimes were being prosecuted for not going ahead with the prosecution when it was fairly, perhaps fairly clear, or at least highly suspect, that actually, yeah, this probably was a crime committed and she's been lent on or whatever. So obviously that, that was a very undesirable situation. So what happens now if somebody drops out and, and the Crown decide, we'd still want to proceed? Well, they can try with just other evidence. They can try and say, have we got a case without the victim, complainant's testimony? Because, like I say, we prosecute murders all the time and we don't have, any evidence from the victim there. They can, like I say, witness summons, but that's considered undesirable. They can, in certain rare circumstances, when special conditions apply, they can just put the victim's statement in and say, this is what the victim says. But then, of course, there's no opportunity for cross-examination. And judges will, warn juries and say, and juries tend to just think of their own volition. Well, hang on a second, it's not really fair here. We've not, this evidence hasn't been tested. But, that is one of the problems. But there you go. So, like I say, victims, they cannot, press charges, they cannot drop charges. And this is what happens. So, sometimes when they do just go, I'm not going to cooperate, and there's no other way of doing it, there's no other evidence, there might be previous inconsistent statements or something, and they know that putting just, the victim's statement in isn't going to get them home, then the CPS will discontinue in those, in that situation. But yeah, there you go. If you found that useful, please consider clicking the like button, subscribing and sharing.